sure how many, but a good number of people that are logged in. And obviously, anything that you might talk about, if you want to ask a question during the program, that's not going to be attorney-client privilege. Everybody else is going to be able to hear you ask those questions. So I guess bear that in mind. And this seminar isn't obviously, I hope it's obvious, it's not creating an attorney-client relationship between myself and anybody who's tuning in. Obviously, if there was a reason that you wanted to hire me to represent you as an attorney, that would be different. But for the purposes of this seminar, it's informational only. There will be questions and answers, as I mentioned, and we're going to do that in about 4 different sections. We'll kind of talk about all of the I guess topics that we need to cover, and I'll break and ask if anyone has any questions, and we'll kind of make sure everybody's questions are answered, and then we'll move on to the next section. At the end, there'll also be a question and answer. We'll also stop for maybe 10 minutes in the middle, somewhere in the middle of the seminar, for get some coffee, stretch your legs, whatever. And let's see. I think you probably received a PowerPoint that I put together in an email that we sent to you. Kim sent to you. Kim's here helping me. Thank you, Kim. And Dave Wisniewski from Safer Arizona is here helping me on the media side of things with the camera and so forth. So thank you, Dave. And let's see, what else as a preliminary? This is we're focusing on talking about home cultivation today. And so let's go ahead and get started. As you know, I'm sure Smart and Safe passed in November of 2020. It was enacted in late November, became officially the law in late November, which at that point allowed everyone who chose to possess up to an ounce of marijuana, of which 5 grams can be in the form of concentrates, and can also grow 6 plants. In this, I should say, this only applies to adults who are 21 years or older. When I use the term adult tonight, I'm going to be referring to adults 21 years or older. So these 6 plants can be grown at the person's residence. There can be a maximum of 12 plants per household, and that's what we're going to really dig into here tonight. You can also, the 5 grams of concentrates, just so you know, the definition of a marijuana concentrate for the purposes of Smart and Safe means resin extracted from any part of the plant of the genus Cannabis, and every compound, manufacture, salt, derivative, mixture, or preparation of that resin or THC. It does not include industrial hemp or the weight of any other ingredient that's combined with the concentrate. So like in the form of an edible, it would only be the actual THC concentrate that's in the edible that would count towards that 5 grams, not the entire weight of the brownie or whatever the edible may be. Okay. In my PowerPoint, I had a little chart there. I borrowed this chart from Ballotpedia. I thought they did a good job summarizing some of the penalties that apply if you go over your allowable amount. So you go over 1 ounce, it's not automatically a felony. It is, as long as it's no more than 2.5 ounces, it's a petty offense. Over 2.5 ounces is a felony. For concentrates, if you go over 5 grams, but as long as you're not over 12.5 grams, it's a petty offense. Over 12.5 grams, class 4 felony. So that's important. What is a petty offense? It's a very minor, the most serious crimes are felonies, less serious crimes are called misdemeanors, and the least serious category of crime is called a petty offense. It's like 1 step above a traffic ticket. It's a fine only, no jail or anything like that, just a fine. Also, we're going to talk about, I'm not going to get into talking about like public places, what happens if you smoke in public and that kind of thing, but that's a petty offense as well. We're going to get into talking obviously about cultivation. And so there are certain restrictions that apply there. And we're going to get into detail about that as we go forward. That second page in your PowerPoint of penalties just applies to juveniles. All right. So home grow, home cultivation. Let me just read directly from Smart and Safe Arizona Act. An adult cannot be prosecuted. And by the way, before I read this, just know this is a terrible, long, run-on sentence that could have been written a lot more clearly, but for I think intentional reasons is very vague or ambiguous. But so bear with me. It says that an adult cannot be prosecuted for possessing, transporting, cultivating, or processing not more than 6 marijuana plants for personal use at the individual's primary residence, and possessing, processing, and manufacturing by manual or mechanical means, including sieving or ice water separation, but excluding chemical extraction or chemical synthesis, the marijuana, excuse me, the marijuana produced by the plants on the premises where the marijuana plants were grown. I know, terrible sentence. Excuse me. Let me just read it a little bit. Let me just read the pertinent part to make it more clear. An adult can't be prosecuted for cultivating not more than 6 marijuana plants for personal use at the individual's primary residence. Okay, that's the part of it relative to cultivation. Now, as you know, probably it's 6 plants per adult, but if there's more than one adult in the household, then there can be up to 12 plants at the household. There can never be more than 12 plants at the residence, no matter how many adults live there. So the maximum cap is 12 if there's 2 or more adults that are actually residing there. And it's important to understand that it has to be at your residence, not at someone else's residence. And you can't have plants that you can't, if you're only one adult who really lives at your residence, you can only grow 6 plants. You can't grow an extra 6 because somebody else is claiming those plants. If they don't really live there, that could be a problem. I want to also point out that we talked about some of those buffer zones, if you will, like if you're over an ounce, but no more but not over 2.5 ounces, it's a petty offense. That doesn't apply to plant count. So if you go over your allowable number of plants, say you're an adult, you're living in an apartment and you have 6 plants. If you go over that number and you have 7 plants, it's not a petty offense. It's immediately a serious felony. As long as you're within your 6 plants, that's fine. It doesn't matter how big those plants are or how much they weigh. But if you have a 7th plant, now it's a felony. And if the total weight of those 7 plants or more, exceeds 2 pounds, then you'd be facing mandatory prison under Arizona law if you were convicted at trial. Now, of course, if there's 2 adults living there, you can have 12 plants. And so you're fine with 12, no matter how much those plants weigh, that's fine. But if you go to a 13th plant, now that's a felony offense. And if the total weight of the 13 plants exceeds 2 pounds or more, I should say, then you're facing mandatory prison if convicted at trial. Now, I'm not saying that you might not be able to work out a plea agreement where you would be placed on probation. And maybe if it was just a very minor transgression, like literally just 1 plant over, your attorney may even be able to negotiate a plea where you would end up with just a misdemeanor, but you'd be charged with the felony. And you don't want to count on, hoping to get a misdemeanor because you have a good attorney. So plant count is very important because going over it means you could be in very, very serious trouble. And when I say mandatory prison, by the way, if the plants exceed 2 pounds, but less than 4 pounds, the mandatory prison is between 0.75 years and 2 years. Okay, so if it's over 2 but less than 4, you're looking at 3/4 of a year to 2 years. If the total weight exceeds 4 pounds, though, that bumps you up into a higher sentencing bracket, and the range of mandatory prison is 1.5 to 3 years. So, a good stretch of time that nobody wants to ever be faced with, much less have to actually experience. Excuse me for my voice. I've got like a little, had a little, I don't know, scratchy voice. I did get tested negative, so I'm all good, but bear with me a little bit on the clearing my throat. I apologize for that. Okay. We're going to be taking a break here coming up so I can get some questions just in case anybody has any questions for me at this point. But and when we get to that point, I'll ask you to raise your hand. In fact, why don't we do that right now? Because we kind of covered a chunk of information. So why don't we take our first question and answer break? If anyone has a question, there should be a little hand icon at the bottom of your screen. If you click that, that'll tell us that you have a question, and then we can get you unmuted.
All right, we've got Let's Grow AZ.
Okay. What? Let's Grow AZ. You're. If you could unmute there, I think you're good. Go ahead.
Yeah. I was just wondering, for all the medical patients out there, they're allowed to carry 2.5 ounces. Would that combine with the recreational amount as well? Would they be able to carry 3.5 ounces?
That's a really good question. I'm going to have to say probably that's undecided. In other words, I think that's kind of a gray area that hasn't been decided yet. My personal opinion is that you should be able to have a total of 3.5 ounces. The reason for that is that a patient may require a particular strain to treat their medical condition. And that strain may not be the same strain that person chooses to, say, have at a party. They might like an indica for their medical purposes, but they might like a sativa when they're, going out or at work or whatever. So I think there's a good argument to say that you get to combine the weight. The caveat is that every prosecutor out there might not agree with me on that point, and so it may have to be litigated. So it's undecided, so be careful about that. Hopefully we'll figure that out here in the next year or so. But I think you can. I think that argument is the better argument, but I guess I have to say it's undecided. How you doing? All right. ASU Dad, go ahead and unmute if you have a question. There he goes.
Yeah, my question is, what constitutes a plant? Is it a clone with roots? Is it a seed that's grown roots and has leaves? What exactly?
So that's actually just what I was going to get into at the beginning of the next section, but I'll just say it now as an answer to your question. There isn't a definition in Smart and Safe, nor was there a definition in the Medical Marijuana Act for a plant. There's been no court case, believe it or not, in these 11 years. There's been no court case that has defined what a plant means under the Medical Marijuana Act. So most cannabis attorneys, which I consider attorneys who practice a lot in cannabis law, particularly criminal defense, agree that the best definition that we have to work with is a definition from a case in the Ninth Circuit Court of Appeals. The Ninth Circuit is a federal court of appeals, and its jurisdiction includes all the West Coast states, including Arizona. And so the definitions that the Ninth Circuit comes up with are very persuasive and often adopted by Arizona cases. And the reason that they decided to define a plant is because under federal law, some of you may know, if you go over 99 plants, then that can trigger mandatory prison. And so it was important under federal law for the court to establish, okay, then exactly what is a plant? And here's a definition from that case. It's called United States v. Robinson from 1994, Ninth Circuit case. Quote, until a cutting develops roots of its own, it is not a plant itself, but a mere piece of some other plant. We therefore adopt the rule that cuttings are not plants unless there is readily observable evidence of root formation. So in other words, if it has roots, even fundamental kind of rudimentary roots, if you can see them, and possibly with the aid of a magnifying device. If you can see roots, that's going to be considered a plant. If it doesn't have roots, it's, as it says, it's just a part of some other plant, and it doesn't count. So that's the best definition we have. Most attorneys would agree with me who are knowledgeable in this area of law. And so that's what we're going with. And I think that is likely what the Arizona courts will agree with if and when there's a case where they have to make that decision. Okay, anyone else?
Oh, yeah, we got Omar.
Omar, go for it. Yeah, Omar? I don't know, Omar, we can't hear you. I'm not sure. Are you unmuted over there?
Looks like it is from my end.
You're unmuted from our end, Omar. I don't know if maybe there's something going on with your microphone. So we'll move on. If you figure that out, just raise your hand again. Sorry about that.
All right, next up, we got Dave.
Dave, if you would unmute, go ahead. Just says Dave. You gotta unmute, Dave, if you still have a question.
The mute button's by your name.
The mute button is down by where your name is on the screen if you're having a hard time finding it. Okay, Dave, we'll come back to you if you figure that, if you find that, just raise your hand again.
All right, Elkin.
Elkin, if you would unmute. Okay,
All
go
right,
ahead.
all right, you can hear me?
Yeah, I can hear you.
Okay, my question is to you is, can I legally grow marijuana at home under lock and key with a felon living in my home?
Yes, you can. Now, that felon, if they're currently on probation or parole, that could be a problem for them, okay? And that they would need, if they are on probation or parole, they would need to check with their PO to make sure that that's not going to get them in trouble. Now, there also can be an argument. Let me answer it a little bit more thoroughly. Under Arizona law, we know that a medical marijuana patient has the right to medicate while on probation or parole or while on felony release. We don't know if the courts are going to extend that to people under 207. They might say you can't they might say, well, look, like we said, you can't interfere with the medical use of marijuana, but the recreational use they may find, just like with alcohol and other substances, legal or otherwise, the court can prohibit you, like when a person's on probation, can be prohibited from using those substances, even though those substances are not themselves illegal. So that means a couple of things. One, the person with the felony, if they're still on probation or parole, that could be a problem for them. And also it could be a problem for you because if you are making available to them something that they've been prohibited, I don't think it's a problem. Let me analogize this to firearms. When a person's convicted of a felony, until they get their rights restored, it's illegal for them. It's a crime, a felony for them to possess a deadly weapon. If you made a deadly weapon available to that person, you could be charged with aiding and abetting the illegal possession of a firearm. The difference here, though, is marijuana is not illegal for someone who has a felony under Arizona law. And maybe this is a good time to just remind everybody that this still remains completely illegal under federal law. And so there's a difference between the person being on felony probation or parole, federal probation or parole versus Arizona state probation or parole, because this is still illegal under federal law. I don't want to get too complicated, I don't want to get in too much detail here, but I don't think under Arizona law that you would get in trouble because your roommate who might be on probation or parole is living in your home where you're cultivating marijuana, as long as you're taking precautions to keep the door locked. Okay. But if they're under federal probation or parole, that could be a problem for you too. If they're not on probation or parole at all, and they just happen to have a felony conviction, no problem. Nothing to worry about under state law. Okay. So I hope that answers your question. I mean, it gets a little complicated, but that's the base. That's a basic answer. Okay.
Oh, okay, thank you.
You bet.
All right. Well, it looks like Dave made his way back.
Dave, do you want to give it another shot?
Can you hear me?
Yeah, we can hear you now.
Okay. You talk about weight. What if you have 6 plants that are all blooming
Yeah.
or budding out or even hanging up to dry, and your neighbor calls the cops
Okay.
because of the smell,
Uh-huh.
and you have, you say you can have up to 2 pounds.
Okay. Gotcha. So that's a 2-part question. The second part where you talked about what if it's already been harvested and it's drying or whatever, I'll come back to that. I'll address that a little bit later in the seminar. But to answer the question about what about the 6 plants? What if they're really big and they're more than 2 pounds? That's fine because you're allowed. It doesn't matter what the weight is if you're within your 6 plant limit. Because it's not a crime. No matter how much those plants weigh, it's not a crime. You're allowed to grow those 6 plants. But if you go over your 6 plants and you have a 7th plant, if the total weight is 2 pounds or more, then that is where. So you have to first be over your allowable number of plants before the weight matters. As long as you're within your allowable number, the weight there's no issue with how much they weigh. Does that make sense?
What are they weighing? Are they weighing the whole plant?
Yeah.
Or just
Everything.
the buds or the leaves or what?
Right. So we're going to get into talking about the definition of marijuana under smart and safe, but once you're outside of the parameters of smart and safe, you're then into the criminal code and the definition of marijuana under the criminal code. And that definition includes all parts of the plant except for the mature stalk. As a practical matter, it also includes the roots, but not the mature stalk. But it is wet weight though. They can weigh it wet. It doesn't have to be dried. Like you might, I don't know if some of you are probably familiar with under the Medical Marijuana Act, there's a distinction between, usable marijuana. The weight only applies to the dried flower. That's not the case under smart and safe. It applies to all parts of the plant. But again, we don't get into that until you're over your allowable number of plants. The weight doesn't matter until you're over your allowable number of plants. But if you are, the entire plant is weighed except for the mature stalk of the plant. Okay.
What if you have 12 plants and your wife is out of town?
That's a really good question, actually. So my answer to that is that as long as that second adult legitimately resides in that residence, if she's just away on a trip, for a couple of weeks or whatever, that shouldn't be an issue. It does get a little dicey though when you're going to be taking care of her plants in her absence. Technically, you are allowed to only engage in, and we're going to get into this question in more detail here later, and I'll come back to it. But you're only allowed to cultivate your 6 plants. You can't cultivate anybody else's 6 plants. So there is a little bit of an issue there about, well, wait a minute, if she's out of town, who's taking care of the plants? She can't designate somebody to do that for her. But I think I'll get into more of that here later in the seminar. Okay.
All right. Thank you.
Yep.
Okay. Omar, Graham, Ken.
Okay, Omar, you want to give it another shot?
Hello, can you hear me?
Yeah. Okay. Now we can hear you.
Well, a friend of mine had a question about because he has kids in his home, and he's also a gun owner.
Okay.
Would that be a problem to cultivate?
All right. So 2-part question. 1, is it a problem to cultivate with children in the house? And 2, is it a problem to cultivate with a firearm in the house? So again, under Arizona law, we're not talking about federal law, obviously. Hopefully we're going to see legalization on the federal level here in the next few months. I think that's very, very likely in the next year, certainly next 2 years. But anyhow, we're talking about Arizona law here. With kids, it can be a problem because if you have minor children, they can allege that the parents' marijuana use is causes child neglect or child endangerment. And in many cases, they may be able to get away with that. Under the Medical Marijuana Act, there's really good protections for parental rights. Under the Medical Marijuana Act, if you have your card, and this is one of the main reasons I tell some people to consider keeping your medical marijuana card if you have minor children, because DCS loves taking away children from people who choose to consume cannabis. And under the Medical Marijuana Act, it said that custody and visitation cannot be disturbed because of a parent's medical use of marijuana unless the medical use presents an unreasonable danger to the safety of the child, and that must be proven by the state or by, if it's in a custody battle, by the other spouse, by clear and convincing evidence, which is just below proof beyond a reasonable doubt. It's not just preponderance of the evidence, which is more likely than not. It's by clear and convincing evidence, it would have to be proven that it presents an unreasonable danger to the safety of the child. We don't have that language in Smart and Safe. Unfortunately, there's a general immunity provision. And the idea from the campaign was, oh, that's good enough, which I don't agree with, because I've seen what they do over in juvenile court in these dependency hearings. But the idea was that general kind of immunity protection would protect parental rights as well. We'll see, but I think it's very risky. So if you are a parent with minor children, I would encourage you to keep your medical marijuana card because it has those additional protections. The other main reason I tell people why you might want to keep your medical marijuana card is if you are subject to drug testing at the workplace, because this Smart and Safe has no protection for employees. You get positive tests for THC, they can fire you. Under the Medical Marijuana Act, they cannot, unless they can prove you were impaired at the workplace or that you were in possession at the workplace. They can't take adverse action against an employee. So those are the two main reasons why. Now, growing with firearms in the vicinity, not a problem under Arizona law, because the only time that is a problem is if the person is committing a controlled substance offense and has a firearm in the vicinity of the violation, then it's a crime. It's called misconduct involving a weapon. And it's a felony, class 4 felony. But that's only if it's illegal, that there's a controlled substance violation. If you're operating within the parameters of Smart and Safe, there's no violation. And therefore, there's no weapons misconduct. Does that make sense? Okay. All right. Anyone else right now? Because we got to get moving. We got ground to cover here. All right. We'll do a couple. There's looks like 2 more people. And then we got a lot more to cover, so we'll move on. But there'll be more opportunity to ask questions later. So let's get these 2 and go.
Let's go.
Okay, Lloyd, go ahead. Unmute, please.
Hey, how you doing? Dave kind of touched on my my question, but I was kind of wondering. So, say that you have a harvest and then you dried out your plant material and you never went over the illegal amount of plants. Are you only allowed to have, an ounce?
I'm going to get to that. Okay.
All right, perfect.
Okay, cool. I'll get to that. All right, and who else? Zach.
Hey, can you hear me?
Yes, sir.
Hey, Mr. Dean.
Hey,
say
Zach.
you are currently growing under the medical marijuana, the 12 plants, and my wife's
Okay.
growing 12 plants. How with the new laws coming in, can we grow above that with the recreational, or does the 12 plants suffice for medical?
I'm making a note here because I want to include some of these questions in future PowerPoints.
Did that make sense?
No, it makes perfect sense. And you're talking about, I think what you just asked was, and correct me if I'm wrong, because I was kind of making a couple notes here on the previous question, but you said that if the person has more than say it again. I'm sorry. I apologize, Zach.
No, you're fine. Currently growing.
Got you. Yeah. Okay. I got you. Yeah. Similar to that question about how much you can possess, 2.5 ounces under medical, 1 ounce under Smart and Safe. Can you combine those for 3.5 ounces? I think yes. It's probably going to have to be decided, but in the context of plants,
Okay.
if you're authorized to cultivate 12 plants under the Medical Marijuana Act, can you grow an additional 6 plants under Smart and Safe? Is that the question?
Yes, sir.
Yeah, I think the answer to that is I think yes, and for the same reason, because you're given the right to grow marijuana plants for medical use. So you're going to be growing a strain, obviously, that's effective for you, or if you're a caregiver, that's effective for your patient. And that's not necessarily the same kind of strain that you would choose to grow, for just having fun. So I think you're authorized under medical to grow 12. You're allowed an additional 6, in my opinion. But like the previous question, I'm sure that there will probably be some prosecutors that disagree with my interpretation, and it will have to be litigated. I think we ultimately prevail, but knowing that it's a gray area, undecided area, you want to be careful about, publicizing that fact until it's straightened out. So, maybe this is a good time to say, I heavily discourage people from posting. And I'm going to make a note of your question here. Okay. I caution people against posting photos of their grow or photos of their harvest, because if law enforcement looks at that and they don't agree with what I just told you, that you can combine it, and they think, oh no, you can only have the 12, you can't have an extra 6, they'll figure out how to get a search warrant and come in there and cause a problem for you. It could become a problem. Same thing with harvest. We're going to get into talking about this, but if you got pounds of marijuana, I know it's exciting. You're proud of what you did. Resist the temptation to post photos or make comments, on social media about that, because there's certain people in law enforcement and prosecuting agencies that may have a differing opinion. And there's always a judge out there somewhere that they can get a warrant from. And you don't want to have that problem. So just in general, I would caution people from, posting until some of these undecided issues, like what we're talking about right now, are resolved in court. I would resist the temptation to become a guinea pig on that issue. So does that answer your question?
Yeah, thank you very much.
All right. I'm making a note of that too, because I want to include your questions, in future PowerPoint presentations, so that, what you have in writing is thorough. Okay. So let's move on. Let's move on, start covering some more ground here. Okay. So you can, as you noticed from that, when I read the immunity provision, you notice that you're allowed not only to cultivate, but also to process marijuana. And I'll read it again. An adult cannot be prosecuted for possessing, transporting, cultivating, and processing. So what exactly is cultivating and what exactly is processing? Cultivating means to, and this is straight from the act, propagate, breed, grow, prepare, and package marijuana. Processing means to harvest, dry, cure, trim, or separate parts of the marijuana plant. Those things you're allowed to do, both the cultivating and the processing at home with your plants. And we're going to talk a little bit more about this. I'm not going to jump ahead. So that's important to know. You're allowed to engage in all of those activities. So up to 6 plants or 12 per household if there's 2 or more adults there. What are the restrictions on where you can grow? Similar to the Medical Marijuana Act, you can grow within a closet, a room, a greenhouse, or other enclosed area on the grounds of the residence. So it can be inside the house or it could be outside the house in a greenhouse, for example. But it has to be equipped, whatever that room or greenhouse or enclosed area is, it has to be equipped with locks or other security devices that prevents access by minors. So the enclosed area, that's a kind of subject to interpretation. If you look that up on like in a dictionary, Some of the definitions talk about it's got to be surrounded by walls. Sometimes they say it's got to have a ceiling. I don't think that this interpretation would mean that it has to have an actual ceiling. I think an enclosed area in an outdoor grow would qualify without a ceiling. Otherwise, how are you supposed to have an outdoor grow, obviously? So what is it? It has to be enclosed though. So certainly it's got to be surrounded by some sort of a fence. Under the Medical Marijuana Act, the department attempted to define the term enclosed area to mean, and I disagree with their interpretation. I don't think the courts would agree with them either, that the outdoor grow had to be surrounded by a 10-foot concrete wall with an iron gate. I don't think that that's a reasonable definition of an enclosed area. I do think, though, that it's going to have to be surrounded by enough of a fence that it prevents access by minors. So a white picket fence, with a little door on it and a lock, that's not going to be sufficient. Probably just a regular old chain link fence isn't going to be sufficient either, because I know when I was a kid, I could clear one of those in less than half a second. So we're talking about something more with that is more secure, probably a very tall fence, barbed wire with a door that can be locked. I'm thinking now we're getting into in a reasonable example of an enclosed area. There is no definition though, so it's got to be subject to interpretation, and the courts are going to have to look at this. And unfortunately, they never did under the Medical Marijuana Act, believe it or not. When I say the courts, I mean, we've argued about it in trial courts and stuff, but we don't have an appellate court decision. And until we have an appellate court decision, like from the Arizona Court of Appeals or the Arizona Supreme Court, it doesn't mean anything. It's not precedent. So we don't have that, unfortunately, under the Medical Marijuana Act defining enclosed area. I think, there weren't a lot of people that were growing under Medical Marijuana Act because of the 25-mile rule. We're going to have a lot more people growing now, obviously, and probably I foresee that we're going to have to deal with this question of what is an enclosed area. So if you want to grow outdoors, just understand that we don't have a definition of what that means, and to exercise caution, err on the side of caution. Think about when you were 13 and what would prevent access by you. It doesn't have to be a lock. It can be other security devices. What are those? I mean, a pit bull tied to the door. I had a client who his enclosed area was protected by attack peacocks, which I guess are pretty aggressive. It didn't slow the cops down very much though when they raided the place. So it could be security cameras that are being constantly monitored. Arguably that could qualify as other security devices, but just err on the side of caution. It's got to be secure. It's got to be locked. The whole thing has to be prevent access by minors. Okay. Now the good news, if you end up getting caught with something that, let's say, doesn't qualify, either the bedroom that you're growing it in isn't locked, and so the kids can just walk in there, or you have an outdoor enclosed area that's surrounded by a 3-foot picket fence. If that happens, the good news is that it's a petty offense the first time. The first time, it's just a petty offense. You're going to get fined like $100. That's it. Second offense, class 3 misdemeanor that could entail jail time potentially, but a fine, jail time, possibly. But the good news is that if you do try it out and it turns out somehow a neighbor calls the police, my neighbor's growing marijuana outside and takes photos, and they say, oh yeah, that's no good. They come in and they charge you with felony, or they say that you're not in compliance with smart and safe. They can only charge you with a petty offense the first time. So at least that's like a fair warning, okay, pay a fine, do it better next time. The second restriction on where you grow, besides it being in a secure, locked closet room, greenhouse, or other enclosed area is that it has to take place in an area where the marijuana plants are not visible from public view without the use of binoculars, aircraft, drones, or other optical aids. So the question is, what is public view? Certainly public view would be like if people are driving by and can look through your window and see the plants, or from the sidewalk. Certainly that would be public view. But what about if you have them outside in a greenhouse or an outdoor grow situation and your neighbors can see it, like from their second story window or whatever, they can see the plants? Is that public view? I mean, they're looking at it from their private residence. Public view isn't defined here, so we have to figure it out on our own, common sense definition. I think there's an argument that that's not public view, but an argument could also be made that maybe it is public view. But regardless, the good news is if it turns out that some snoopy neighbor calls the police and they say, oh yeah, that's public view. First of all, you say, what are you talking about? They're viewing it from a private residence. How is that a public view? But second of all, if they do find you responsible, just a petty offense, first offense. Second offense, again, class 3 misdemeanor. So if you're growing outside of an enclosed, locked area, it's a petty offense, first offense, class 3 misdemeanor, second. If it's viewable from public view, first offense, petty offense, fine. Second offense, class 3 misdemeanor. So the good news is that if a court does end up disagreeing with what you think is public view or what you think is an enclosed area, it's just a fine the first time, and then you can correct, or adjust after that, or appeal. Because why would you plead guilty to the petty offense? I mean, you'd want to litigate that, right? And if you lost, you want to appeal it, take it up, so we can start to define these things, because the only consequence is you have a petty offense. So that's kind of the good news, even though that's maybe a little bit ambiguous. It's not going to be terrible. It's not like you're going to have a felony like what it was before Smart and Safe. Okay. I covered both that. All right, great. Let me cover one other topic and then we'll open it up for questions again. A lot of people want to know, where can you get your clones or seeds so that you can, start a grow? So legally, you can obtain clones or seeds as a gift from another adult for free. Can't give anything in exchange. We're going to talk about that a little bit later, but for free if someone gives it to you. But remember, if those clones are rooted, they're going to be considered a plant, and under Smart and Safe, you can only share up to 6 plants. So if they're rooted clones, only 6 of them you can give. If they're just clippings, then it's up to an ounce worth of clippings. And we're going to talk about this a little bit more detail about sharing. Or you could purchase them from a marijuana establishment. In fact, I think, Dave, you were just telling me that there's a
I heard Phoenix Dispensary.
Phoenix Dispensary is selling seeds. I don't know for sure if that's true, but that's what I've heard. And I think probably other dispensaries. So you can buy them legally from dispensaries, seeds or clones, or you can receive them by gift. You can't give a donation, nothing like that. You can receive them by gift from another adult. But here's where you definitely cannot receive seeds or clones. You can't buy them from another adult unless they're working at a marijuana establishment, a licensed marijuana establishment. And you cannot import them from another state. If you get caught importing marijuana, that's a felony offense, even if it's within your allowable amount. So even if you are coming from California into Arizona with 5 grams of marijuana, that's a felony offense. It's the crime of importing marijuana. So nothing in Smart and Safe gives an adult the right to import marijuana from another state. So that remains a crime. So be careful about doing that. or telling a cop that that's what you did if you get pulled over for a traffic ticket and he says, I smell marijuana, where'd you get that? Exercise your right to remain silent, because if you tell him I got it in California or Colorado or Nevada or whatever, they could potentially charge you with serious felony offense. It's not going to be a prison type offense unless you have priors, in which case it very well could be mandatory prison. If it's a first offense, it's highly unlikely that that's going to involve prison if it's, within your ounce. And obviously if you have pounds, now you're a mule, basically, moving pounds in interstate, and that's can be a very serious situation. So, in any event, to keep it simple, the only two places where you can legally obtain is by having seeds or clones given to you in the state of Arizona by another adult, or if you buy them from an Arizona licensed marijuana establishment. Okay, so now's another good time, I think, to take a quick break if anyone's got a question. Corey, go ahead.
Yeah. Can you hear me?
I can.
My question is I'm good. How you doing?
Good, thank you.
My question is the purchase of seeds like online. Obviously that's highly illegal to do that as well, probably.
That is illegal because I'm going to read the definition of marijuana here. If I didn't, yeah. So let me just skip ahead real quick to answer your question. Marijuana means all parts of the plant of the genus Cannabis, whether growing or not, as well as the seeds from the plant, the resin extracted from any part of the plant, etc. So the definition of marijuana under 207 includes seeds, and under 207, you're only allowed to sell marijuana legally if you have a marijuana establishment license. So selling seeds requires a marijuana establishment license, which are obviously very difficult to come by. And having, for example, a seed dealer's license from the Department of Agriculture, that only applies to legal seeds. You can't sell marijuana seeds unless they've been sterilized, and that's common to have sterilized marijuana seeds in like bird seed. But the reason why you never see any little marijuana plants growing up at the base of your bird feeder is because all of those seeds have been sterilized, rendered incapable of germination, usually through a steaming process. They're basically cooked so that they can't germinate. You can sell those with a Department of Agriculture seed handler's license, but you can't sell them if they're capable of germination. That's a felony offense. That's selling marijuana, and it requires a marijuana establishment license. That's the only way to legally do it. These are interdicted by both federal postal inspector's office and state. If they find, for some reason, if they determine that someone's selling seeds, it's just a matter of time. They will aggressively investigate that, and there will be eventually a raid and felony charges to the person selling them. If you're the person buying them, what usually happens is you'll get you'll be contacted by the post office, and they'll tell you, we intercepted a package. Before we can release it to you, we need you to come down to answer some questions. Good idea to just decline and not go and answer questions, because inevitably they're going to try to tie you into either charging you with a crime yourself or pressuring you into cooperating in an ongoing criminal investigation. Oftentimes, people who are selling seeds are selling interstate, and that's why DEA and FBI, postal enforcement, gets involved, because it's an interstate network supply chain, and they like to go after those. So, you could potentially be charged with soliciting the sale of marijuana, just like, you know, in prostitution, Johns, what do they get charged with? They don't get charged with prostitution. They get charged with soliciting prosecution. And that's a crime. Also, theoretically, soliciting cannabis through the mail, soliciting marijuana is also a crime. Now, we don't usually see a lot of that, but definitely a person could be charged with soliciting marijuana. So, yeah. So, does that answer?
Yeah, that answered it thoroughly. Thank you.
Yep.
All right, let's grow AC.
Okay, let's grow again. Go ahead.
I have a two-part question, just
Sure.
referring back to the first section on the first one. I just want to clarify a little bit for people. When you're harvesting your plant and you have now harvested over 2.5 ounces and they have came into your place, because having 2.5 ounces is a felony, how do you prove that came off of your plant?
I'm going to get into that here just in the next, as soon as we're done with these questions, that's where I'm going right into that. Okay. Second part, go ahead.
Oh, I didn't know.
He had a second part. Yeah.
You know, that's weird.
You have to unmute on your end. We're
There
not
we go.
hearing- oh, there you go.
It wasn't letting me at first.
Okay.
Sorry. And then medical patient question. To more of this side. I have a medical patient card in New Mexico as well,
Okay.
as of Arizona. Am I allowed to transfer from state to state?
No,
Being a medical patient
you're
in
not.
both states?
You're not, because you're not, as a patient, you're allowed to possess and use and consume the marijuana. You're not allowed to import it into another state. That remains a crime in both Arizona and New Mexico. So I know it's crazy, right? But the law is that even though you're allowed to possess it in both states, if you import it, that's a crime if you get caught. So, I mean, a lot of people do it, obviously, and they don't get caught. Some people do. And when they do, it can be a problem. So now, usually I'll tell you this. Normally what happens is they decline prosecution, even though they know you brought it from another state, even though they know you imported it. If it's within your rights, as a matter of prosecutorial discretion, in most cases, they'll decline to prosecute, but not always, so just bear that in mind, when you're deciding what to do. I can't hear you again. Let's grow. It keeps muting. Go ahead.
No, thank you. No, I'm good. I was talking to my partner.
Oh, okay. All right. Anyone else right now?
Yeah, we got Dave.
Okay, Dave, go ahead. Go ahead, Dave.
Since weed stays in your bloodstream so long, what's impaired at the workplace or impaired driving?
Okay, this is a little bit beyond the scope, but of what we're talking about today. But I do another seminar that's more general to 207, not focusing so much on cultivation. But to answer your question, the new DUI standard is that they have to prove impairment. They can't. It's not a crime just to have THC in your system. They have to actually prove that the THC caused you to be impaired. They have to prove that beyond a reasonable doubt. Now, all they have to prove is that it's enough to cause you to be impaired to the slightest degree while driving. But it's definitely a lot better than what it was, which was any amount of active THC was automatically, or active THC metabolites automatically DUI. And those metabolites are detectable for several days. So driving wise, it's a matter for the jury. If the jury believes that the state has proven that you were impaired to the slightest degree, then they're supposed to find you guilty. And that's what those trials are all about. But at least we get to have a trial. It used to be automatic. If a person had THC in their system, it was DUI. unless they were a patient. I took a case up to the Arizona Supreme Court and established an affirmative defense for patients, but it was like a guilty until proven innocent. At least it wasn't automatic, but the patient had to prove that the THC was insufficient to cause them to be impaired. Now the burden of proof is back where it belongs, and the state has to prove beyond a reasonable doubt that it did cause the person to be impaired. There is a House Bill 2084 right now. I don't think it's going to get through, but it's seeking to impose a presumption of impairment at 2 nanograms, which is really low. Most regular cannabis consumers are going to test around 5 to 12 nanograms per milliliter. So a presumption at 2 is absurd. I don't think it's going to pass. We're keeping our eye on it. If it does, I think it violates the Voter Protection Act, but I don't want to get too far into all that. As far as at the workplace, an employer doesn't have to prove beyond a reasonable doubt that you were impaired at work, like in a DUI. Basically, they have to prove that they had, probable cause to believe that you were impaired at the workplace. And that's just a case by case thing where they'd have to show, typical things are like bloodshot, watery eyes, delayed reactions. Some people try to claim, cops claim a green film on the person's tongue is an indication of recent marijuana consumption. They could say that you're, clumsy, or that you're showing an inability to coordinate with basic tasks, things like that. It's a combination. And so if the employer has probable cause, has a collection of those observations, most employers, or a lot of employers, have a drug testing policy that says if they have probable cause of impairment, they're then allowed to test you. And then if you get tested and you have THC, their policy will be that you're fired. Or it could be a random drug testing policy where you just caught up in a random thing, you test positive, you're fired. They can do that under this law. Now there's an argument, there's no argument that there's nothing in 207 or anything from the people who brought us 207. They've never claimed that there was any employment protections, and there's not. So again, one of the reasons why you might want to have a medical marijuana card if you're working for someone who has a drug testing policy. What was the other, did I answer the question?
Yeah, if you don't have kids, you still have to have it locked up.
Yeah, the thing is I think the question is, well, what about if my whole house is the enclosed area? I just keep the front door locked and I don't ever let kids in. If you never let minors in, and the whole house was locked, I think you could qualify that as the enclosed area. The thing that makes me hesitate is the examples that they give: closet, room, greenhouse, enclosed area, tends to suggest that it's supposed to be some smaller area, some subdivision of the house. So there could be some pushback on that, but I think there's a good argument to say that as long as your door is always locked and you never, ever let minors in the house, then the house could be the enclosed area, the whole house.
So
that's my
really
opinion. Some people might disagree with me, but
there's still a lot of really gray areas in all of it.
There are, yeah, I know there are. We'll get through them, but best I can tell you now is what if it's subject to interpretation, like I'll let you know. I think the better argument is yes, you could do that. But again, I work with these crazy prosecutors, all the time, coming up with crazy theories about things, always on the hunt to try to figure out how to persecute cannabis consumers. And so I don't have a hard time imagining a prosecutor, having some issue with that. But I think you're on pretty good ground to say that would be okay.
All right, thank you.
Yep.
All right. Last one up, Qualifier Farms.
Qualifier Farms.
Hello.
Hey, man.
Yeah, so as a licensed caregiver, if we want to donate our our product, let's say hypothetically speaking, anywhere from 5 to 7 pounds to a company that wants to enter the commercial space doing either concentrates, edibles, RSO, etc., may we donate that to them, and in exchange, we provide consulting on this is our best practices when it comes to our methodologies on making RSO, so that when you go and get lab tested, you'll pass and you can provide all the profiles of what your product is displaying. But I'm from the caregiver world, and we live in a pretty big gray area. So that's why I hopped on to figure out if that's cool.
There was a time when that was, I would say that was a gray area, undecided area. It's not anymore. Ever since 2015, in a case called State v. Matlock, the Court of Appeals settled this issue once and for all. I was leading the charge on this issue. It's the same idea about, patient-to-patient transfers, and you charge a delivery fee, or you charge a consultation fee, or whatever. There's all kinds of different business models with compassion clubs and farmers markets. Some of them, are schools. You charge tuition. I had a client that was selling $50 pencils, and then you got a free eighth ounce of marijuana. So there's all kinds of different models, but what they all have in common is the fact that you're transferring marijuana, and then you're charging money for some other product or service. The courts are going to always say, and prosecutors and cops are going to always believe, that if there's any money that's involved, that at least some of that money was paid in the expectation of receiving marijuana. And one of the ways that we can say that they argue, it's definitely not, the marijuana really isn't for free if you had to pay money for something in order to get it. So like if the question is, look, do people have to first pay you a consulting fee in order to get the free marijuana? If the answer is yes, then it ain't free. Or if the more money someone pays you for the non-cannabis product or service, do they get more marijuana? If the answer is yes, when obviously the marijuana is not free. Is the market value of the non-cannabis product or service not related to that product or service, but more related to the amount of marijuana received? Then that means that's evidence that the marijuana is not for free. It's the consultation that's for free. So you can't get away with that anymore. They find out about it, they're definitely going to go after it. We obviously know it happens. There are still dispensaries out there that will pay under the table, and they'll act like it's no big deal because so far all they get is a slap in the wrist. But my clients come to me when they get busted, the ones providing it, and they face serious felony charges, and the dispensary gets like a warning write-up. And that's just, unfortunately, the industry is treated differently than the public, than the cannabis consuming community. It's not right, but that's the bottom line. And that's why sometimes you see dispensaries kind of talking about it like it's no big deal. I even know of a dispensary who used a false departmental form to induce caregivers. And they said, we can pay you a reimbursement. You just have to fill this form out. And it looked like it was like a modified departmental form, and it looked really official because they wanted the marijuana and they wanted to make the caregiver feel like it was okay for them to be reimbursed for it. Totally illegal. And the caregivers that fell into that got in trouble. And they had freaking evidence of it. They had like the sheets, these forms. But I think that there was some consequence to that dispensary for that because of the fraudulent forms and all that. But generally there's not. So no, you can't do that. There's really no scenario or business model under which, if law enforcement found out about it, they're going to be coming after you. So I know it sucks. Believe me, I fought this hard. Had some early success down in Pima County. Got a motion to dismiss granted. That was the Matlock case. The state appealed it to the Court of Appeals. The Court of Appeals, definitively said absolutely not. Case called State v. Matlock from May of 2015. I talked more about that in a different seminar. I didn't want to get too sidetracked, but it's a good question.
Thank you.
Yeah. Okay, good. So let's keep, okay. Yeah. Maybe this is a good time to take our 10-minute break. We have some good topics coming up. We're going to talk about allowable amount. How much marijuana can you have at home? We're going to talk a little bit more. We're going to talk about helping other adults to cultivate. We're going to talk about sharing marijuana, a little bit about what we just talked about, answering that question. I'll talk maybe a little bit more about that. Maybe we covered it good enough. I don't know. But, make sure everyone understands, hey, you can't sell the marijuana you grow. And then we'll talk a little bit about search and seizure and how cops might get into your home to search it. And there's good news on that front too. So we'll see you guys in about 10 minutes. Go get a cup of coffee, smoke a bowl, stretch your legs, and we'll see you back here in about 10 minutes. All right, everybody, welcome back. So to the second part of the seminar. We've covered more than half already, so I guess we're not really at the halfway point. Let's see, is everyone back in there? Okay, great. All right, so allowable amount of marijuana at home. Obviously, we know that you can have an ounce of marijuana outside the home. You're limited to an ounce. If you go over an ounce, but you're at least not more than 12 and a half ounces, it's a petty offense. Over 12 and a half ounces remains a felony. So what about at home, though? This was a question we all dealt with under the Medical Marijuana Act. You can have 12 plants, but you can only have 2.5 ounces. How is that? That's a dichotomy. That's inconsistent. And unfortunately, the courts, when they looked at this issue or a related issue anyhow, in a case called State v. Gilly from, I think that was 2016, the Court of Appeals said, look, we didn't write this law. We know it's really difficult to comply with it, but all we can say is just be really careful not to go over your allowable amount. We never got a decision directly on point where a person had more than their 2.5 ounces at home, and then their defense was they're allowed to have more than 2.5 ounces because they were authorized to cultivate. We never actually had a court of appellate court rule directly on that issue, but in State v. Gilly, in what's called dicta, in their opinion, they did say a lot of things that didn't bode well for that defense, but we never actually got a direct answer. Similar problem here, obviously, but fortunately, the drafters attempted to, they wrote the law intending, they say, that a person was allowed to have as much marijuana at home in the locked room as they cultivated from their legal grow, as they harvested from their legal grow. The statute, unfortunately, is kind of ambiguous. I brought this to the attention of the drafters and asked them to clarify it. They declined to do so. And so we're left with an ambiguous statute. It very well may be litigated. I think that there's going to be a prosecutor or prosecutors that are going to say that they don't think you can have more than an ounce even at home. I think that we will win that argument. I think that there's enough in the statute for us to prevail. But it is, unfortunately, probably another slightly gray area. And this is, again, comes back to my point about not posting photos of like pounds of marijuana and that kind of thing, because somewhere there's going to be a prosecutor who decides he thinks he can win the argument the other way. So the provision, and I read it at the beginning, but I'm going to read it now more with an eye towards having, more than an ounce at home. So the immunity provision says, and I'm going to just read the pertinent part. Well, let me read the whole thing first, and then I'll read it, though, just pertinent part to where I think it supports that you can have more than your 1 ounce that you grew at home. An adult cannot be prosecuted for possessing, transporting, cultivating, or processing not more than 6 marijuana plants for personal use at the individual's primary residence, and possessing, processing, and manufacturing by manual or mechanical means, including sieving or ice water separation, but excluding chemical extraction or chemical synthesis, the marijuana produced by the plants on the premises where the marijuana plants were grown. Now that's again, I hate that. I really don't like that, the way this is worded. But let me read it more specifically in a way. I'm going to cut out some of the part in the middle that is distracting. An adult cannot be prosecuted for cultivating not more than 6 plants, marijuana plants, for personal use at the individual's primary residence, and the marijuana produced by the plants on the premises where the marijuana plants were grown. So when I just read the first part and the last part, it kind of gets more clear that it is saying that you can possess whatever marijuana that you lawfully produced there. So I think we would win that argument. I'm about, I guess, 80% sure that we would prevail, to try to put a number to it. But there is a chance that some court somewhere is going to agree with some overzealous prosecutor that this statute does not allow a person to possess more than their 1 ounce, because it doesn't actually say a person can possess more than their 1 ounce at home where they lawfully cultivated. I wish it said that. It doesn't. Now, that I think they did that intentionally because they didn't want to tip off the voters. They didn't want to say it so clearly that the voters might say, well, wait a minute. They were worried. It turns out it passed by 60%. They didn't have anything to be worried about, but they were worried that voters might say, oh, we don't, oh no, we're not going to go along with that. So they made it ambiguous, betting that the courts would ultimately side with us. I think they will. And so, but again, until that issue is definitively settled, I would not advertise the fact that you have like 50 pounds of marijuana at home, or even 5 pounds of marijuana, because it could cause some problems. So we'll just have to wait and see. But I think we win. Now, so I think that you can have more than 1 ounce if you grew it at home. You'd want to keep it in that same locked area where you harvested it. But there's an important caveat here that I can't really overemphasize. If you noticed, it says that an adult cannot be prosecuted for cultivating not more than 6 plants for personal use. So if law enforcement determined that they thought you were possessing, that you were growing that marijuana for other than personal use, i.e. for distribution, then they're going to say you're not protected. That's the crime of possession of marijuana for sale or possession with intent. So even if I'm right and the campaign accomplishes that a person can possess more than their 1 ounce at home where they grew it, doesn't mean that it can't be characterized as an intent to sell. For example, if you've got 50 pounds at home in vacuum sealed 1 pound bags, very likely if law enforcement finds out about that, they're going to think that that's inconsistent with personal use and consistent with distribution. That happens all the time. There's no magic number, like, is it 5 pounds, 10 pounds, 20 pounds, 50 pounds, 100 pounds? There is none. It's a case by case, but I can tell you for sure, if cops find 50 pounds of marijuana in someone's home, they are going to do everything they can to characterize it as distribution, intended for distribution, which is illegal. And that they even do that with just 10 pounds, most cops. especially if there's other indicators of distribution like scales, the whole setup with a vacuum sealer, certainly ledgers, with people's names and like money amounts or strains and stuff like that. They'll find anything they can and characterize it that way, and they'll say, this is not, you can't use this 50 pounds. You're saying this 50 pounds is for personal use, yet you've got 12 more plants over here that are about to yield another, 10 pounds. This is not consistent with personal use. And they'll say, though, therefore it's consistent with distribution. And so even if we're correct, which I think we are, that you can possess more than your 1 ounce at home, that where you grew it, doesn't mean that you can have any amount and that that you're going to be immune from any potential charges, because they will, if they get suspicious about it, and they will get suspicious if you have pounds of marijuana, because they'll say, gosh, it costs you a lot of money and time and energy to produce this much marijuana in your little 6-plant grow or 12-plant grow if there's more than 2 adults. It's more than you can use personally, and you're still growing more on top of that. They're going to think, yeah, you're definitely intending to sell this stuff on the black market. They do it all the time. I can't even tell you hundreds of cases over the last 25 years that I've been practicing marijuana law, where that's exactly what the case was, that they said this is inconsistent with personal use. The defense is, no, this is personal use. You can charge me with the crime of possession of marijuana. I'm talking about before Smart and Safe, when it was a crime. You can charge me with illegal possession of marijuana, but this is my personal use. I didn't intend to sell it. And the state brings in their experts, their drug interdiction task force detective, and even sometimes like an expert from outside that claims that he specializes in these issues of personal use. I have my own expert witness that I use in these cases because it comes up. His name is Chris Conrad in California, and I'll hire him and bring him in to testify that the amount was consistent with personal use. And so there's a battle at trial about whether this expert, the jury believes this expert, or the jury believes this expert. But it's going to be hard, even for my very good expert, to justify like 50 pounds as consistent with personal use. So that's out. And so once they're able to establish inconsistent with personal use, now they've got you outside of Smart and Safe, because again, that definition, that immunity says it has to only be for personal use. So I'm spending a lot of time on that because I want everybody to know that even though, yeah, you can have more than your ounce, I'm 80% sure of that. There's some disagreement about that, I'll just tell you, among lawyers. But I think we win that. But that doesn't mean that it's an unlimited amount and there's nothing they could ever do to you if they discovered it. So now, and remember that if they are able to prove possession with intent, if it weighs 2 pounds or more, that's a felony offense that carries a mandatory prison sentence of 2.5 to 7 years if convicted at trial. I'm not talking about making a plea deal, but if you fight it and you're convicted, mandatory prison, 2.5 to 7 years. If it's 4 pounds or more, 4 pounds of more, and they're able to prove intent, then the mandatory prison sentence is 4 to 10 years. That's a pretty big chunk of time. So you don't want to be the one, because see what happens in a criminal case is, let's say they find 20 pounds and they're claiming it's possession with intent to sell. You say, no, it's not, it's personal use. And I want to have a chance to prove it. Okay, but if the jury decides that they believe the prosecutor and the prosecutor's witnesses and experts and stuff, that it was inconsistent with personal use, then if it's more than 4 pounds, you're going to prison for 4 to 10 years. And so what happens is, when most people in the cannabis community are not criminal. I mean, they're not criminals. They're not criminally minded. The concept of going to prison has never been anything on their radar, you know? And so when suddenly faced with 4 to 10 years in prison, if you lose, a lot of people are just, too afraid to try a defense, to go to trial and try to convince the jury because of that consequence. And so here all of a sudden you'll have a felony probation deal. Okay, just plead guilty to the felony and we'll give you probation. Most people will say, look, I know, Tom, you're telling me that we've got a good argument and maybe we even have like a 70% chance of winning, but I can't risk 30% or even 10% if the consequence is going to prison for that long. And so they'll take the deal. So just remember that going into it, it takes a lot of courage to go and risk that kind of time. So again, my caution would be, don't advertise it. Don't be posting photos or making social media comments. Man, I got up 50 pounds or what. Just don't do it, because every agency, law enforcement agency, has rookies that just sit there all day long ferreting through social media and uncovering this stuff and initiating undercover investigations and surveillance and all this stuff. So they'll see it. If you're putting it out there, they'll see it. And ultimately it can culminate in a search warrant. And so you don't want to do that. So I'm just trying to be as clear as I can about, don't put yourself in the position of attracting that kind of attention. I will say at this point, I'm gonna talk about search and seizure though. The good news is that now under Smart and Safe, the odor of marijuana is insufficient for probable cause. They can't get a warrant just based on odor, and most of these raids start because a neighbor complains about odor or something like that. Basically what that means is law enforcement has to have something more for the judge to get a warrant than probable cause that the person is growing marijuana, because that's legal. They have to have something more than that. Something like that they have more plants than they're allowed to have. They have more, the marijuana there is inconsistent with personal use, that they have some evidence that the person's engaging in sales, like an advertisement on weed maps or an informant. But they have to have something more. And so that's the good news. It's a lot harder now for cops to get those warrants, but they're going to be trying to find ways to get them. And one good way is they got a photo of somebody with 20 pounds of marijuana at their house. They're going to go and they'll find a judge who will agree with them that it's inconsistent with personal use, issue the warrant, and then you got your door kicked in and they're tearing your grow apart and you end up getting charged with serious felony. So that's all I say is, don't put yourself in that situation. But because you're going to, that protection, that new search and seizure standard isn't going to help you if they can show that some kind of violation or compliance issue. So there you go. That's my piece on that. So, can I help next issue. Can I help other adults cultivate? The answer to that is yes, you can, but adults, as an adult can only engage in cultivation and processing of 6 plants, the 6 plants at their residence. And that goes back to when I read you the definitions of cultivation and processing. Cultivation means to propagate, breed, grow, prepare, and package marijuana. Processing means to harvest, dry, cure, trim, or separate parts of the marijuana plant. You can only engage in those activities in connection with your 6 plants. You can't engage in any of those activities on somebody else's plants. You can't help them trim them. You can't help them grow them. So that's the important point. As long as you don't do any of those things, you can advise other people how to grow, and you can get paid for that. So you can be paid as a consultant, a cultivation consultant. You can even go in there, you can go in their room, their grow room, you can look at the plants, you can even touch the plants to get an idea about nutrients, whether they have any problems with lighting or fungus or parasites or whatever. And you can help, you can tell them what they need to do to fix it. You can even help them set up their grow, go out, get the equipment, the soil, everything. You can even help them set it up. You just can't help them then actually engage in cultivation or processing. So you have to be hands off in a sense. But you can be paid to provide advice to people about how to cultivate. I want to touch real quick on, well, actually, this is maybe here. Let's take a little break here in case, because I know that's kind of a big topic. Does anyone have any questions on anything? Okay, good. All right, moving on. Let's talk about,
We did, but it went away.
Oh.
Yeah, we got it back. Mike.
Okay, Mike, let's get you unmuted here. Mike, go ahead, Mike. I can't hear you, Mike.
Can you hear me now?
Yeah, we got you now.
Awesome. That kind of like circles back to my question. So if we are if they already have seeds and clones, but they don't know what the hell they're doing because like their plants are failing dramatically, we could come in as consultants and say, hey, this is what you're doing wrong.
Yes, but you just can't.
Yeah.
You just can't give them seeds or clones, because if they pay you money for consulting, law enforcement will consider that to be, at least in part, money paid for the seeds or clones.
Perfect.
So yeah, but you can definitely just consult, as long as you're not giving them marijuana, which seeds and clones are marijuana. As long as you're not giving them marijuana, you can be paid for consulting. Okay. All right.
At their location.
At their location, sure.
Yep.
You can go in. You can go in their room, look at it, tell them how to sprout their seeds, or how to grow the clones and transplanting. You can give them advice, tell them about how to do that. You just can't do it for them, and you just can't provide them with the seeds or clones.
So if there's going to be like a co-op of some sense, let's say that somebody wants to get like a warehouse. And
can't do that, but because it's got to be the residence only. It has to be at the person's residence, so no commercial grows.
Got it.
Okay.
Thank you.
Yep. Okay, let's grow AZ, and then we'll get moving here, because I got a couple other things to cover, and then we'll have a final question and answer before we sign off here. Okay.
Will a safe give you better protection on a search and seizure? So if you had your flower or anything locked in a safe, would they have to get an additional warrant for the safe?
No. In fact, that makes them really excited, and they're like, okay, give us a combination, otherwise we're going to blow it. And I'm telling you, I know that they secretly hope that you won't give them the combination, because then they get to bring their explosives in or whatever and blow the safe, and they get excited about that kind of thing.
All right.
Yeah. All they need is the one search warrant. Yeah. All right. Okay. One more. Okay, Mark. Mark, go ahead.
Yes. Good evening. Just jumping back quickly to the amount you can have of marijuana in your home, growing as a recreational law, and the amount that you can have as a caregiver, that differs, correct?
So a caregiver under the Medical Marijuana Act?
Yeah. In addition to the new law.
Yeah, I believe that. So yeah, that's a good example. So a caregiver is allowed to possess 2.5 ounces of marijuana for each of his patients, each of his or her patients, and they can have up to a maximum of 5. And he has to be designated as a caregiver by the Department of Health Services to those up to 5 patients. But that means if he's got 5 patients, he can be holding 12 and a half ounces on behalf of those patients. And so certainly he should be able to have an additional ounce for himself under the new law, you know,
Right,
so.
but with the cultivation and the amount you get off of the plants, if you have even one patient you're growing for and you're growing their 12 plants out, that's a sizable amount of weight of product.
Yeah.
How does that come into play with the other?
So under the Medical Marijuana Act, as I mentioned, the case law indicates that you can only have your allowable amount of marijuana, even though you're growing, you know, like if you have 5 patients, you can have 12 and a half ounces of marijuana for them, but you can grow 60 plants for them. That's obviously, it's absurd that would be a limitation. I still think that we could maybe win that argument when we have a case directly on point, but the cases we do have indicate anyhow that tough luck. So as it pertains to the medical marijuana plants, you really don't want to end up in a situation where you've got more than your allowable amount. Because I'm telling you right now, law enforcement, definitely, prosecutors, absolutely, Attorney General's office, Maricopa County Attorney's office, absolutely are of the opinion that you cannot go over your allowable amount, regardless of whether you're authorized to cultivate. And you'll hear cops say, oh yeah, you can grow your 12 plants, but not all at the same time, because you can only have 2.5 ounces of dried flower. It has to be dry. And I don't want to get too far into medical marijuana.
Right.
But you can have, and they say, well, yeah, you want to just have a rotation. So, you know, you have 3 in clones, 3 juveniles, 3 in veg, 3 flowering, and therefore you have 12 plants growing, but you're only harvesting not that much. And so they made it up. I mean, there's nothing in the Medical Marijuana Act that says you have to do it that way, but that's the way it's presented to juries and judges. And that's definitely what they think. Under 207, though, like I said, it looks like probably you can have more than just your 1 ounce, you know, at home where you harvested it. So they're different, you know, they're 2 different standards that we're dealing with here. I don't know, I think that's the best I can say on that. Okay. All right. Let's talk about manufacturing concentrates. Okay. Processing, manufacturing concentrates. 207 specifically allows adults to, quote unquote, manufacture marijuana, which means to compound, blend, extract, infuse, or otherwise make or prepare a marijuana product. The limitation is that the extraction is limited to non-chemical extraction using manual or mechanical means, which includes sieving or ice water separation, but not by chemical extraction or chemical synthesis. So, you know, definitely no BHO. People ask me, what about like alcohol? What about making RSO with alcohol? This limitation would seems that it would preclude that an adult cannot use even alcohol to do extraction. There is another provision though in 207 that suggests that maybe alcohol is okay. There's a bit of a conflict. I could definitely argue that alcohol is okay based on that, but it conflicts with this very specifically saying no chemical extraction or chemical synthesis other than ice water separation. So, you know, you got to be really careful about if you're doing extraction, how you're doing it. And definitely things like BHO or other solvents would clearly not be allowed, with no question that that's not allowed under, you know, making wax or shatter. definitely that would be illegal. And if you're caught, that's a serious felony, class 2 felony, manufacturing a narcotic drug, because concentrates are considered a narcotic drug, not marijuana, but a narcotic drug. And that's a class 2 felony, manufacturing a narcotic drug. And if, unlike with marijuana, the threshold is not a weight, like 2 pounds. The threshold is a value. If the total value of the extract is $1,000 or more, mandatory prison. So manufacturing concentrates using a chemical process is illegal. And if the value is $1,000 or more, you're facing 4 to 10 years of mandatory prison if you're convicted at trial. So you want to be really careful about how you do it, and not take any chances about doing it the wrong way. So I wanted to, I don't know why I actually have this definition part at the very end, but we talked about this already because someone asked a question. The definition of marijuana means all parts of the plant, whether growing or not, as well as the seeds from the plant, the resin extracted from any part of the plant, and every derivative, mixture, preparation of the plant. It does not include industrial hemp, however, or the fiber produced from the stalks of the plant. We talked about that earlier, the mature stalks and the fiber from that, or the oil or cake made from the seeds of the plant, or the actual sterilized seeds of the plant, incapable of germination. That's not included. So you can possess industrial hemp. Is the weight, there's not the weight limitation if it's industrial hemp, meaning 0.3% THC or less. And you can possess like the sterilized seeds, the fibers, that kind of thing. Now you can't grow industrial hemp, obviously, without a hemp grower's license from the Department of Agriculture. And you cannot sell hemp seeds without a special hemp seed handler's license from the Department of Agriculture. But you can possess, there's not any limitation on the amount of hemp you can possess. And I don't want to get too far into the weeds on industrial hemp. There's a lot of different issues that come up there. But yeah, so all parts of the plant, whether living, growing, or not, that's important. It doesn't matter if it's wet or dry, no distinction there under Smart and Safe like there was under the Medical Marijuana Act. As I mentioned, you can share your marijuana. You can share up to 1 ounce of marijuana with another adult. You can share up to 5 grams of concentrates with another adult, and you can share up to 6 plants. You can give 6 plants or clones to another adult. Again, we're talking about adults 21 years or older, as long as there's what's called remuneration. As long as there's no remuneration. What does remuneration mean? It means receiving anything of value, any form of compensation, reimbursement. It doesn't matter if you call it a donation, same thing. Just semantics are not a defense. Oh, he didn't pay me for it, he just gave me a donation. That's something of value. If you don't believe that donations are compensation, just ask somebody who works for like the American Red Cross. 100% of their salary was paid for by donations. So donations don't make a difference. Anything of value is going to be considered a sale, but you can give those things away. That's fine. Now, one important point I want to mention, 207 actually makes marijuana penalties worse in one way. That is that in addition to all the other criminal penalties already on the books, if you violate, the provisions of the Smart and Safe, you cannot advertise the share. You cannot advertise your sharing of marijuana. It can't be promoted to the public. So even if you're saying, I will share my marijuana for free, and you put that up on Weed Maps or in Craigslist or wherever you can, get away posting it on social media, whatever. Even if you're saying, I have free marijuana that I'm willing to share under Smart and Safe, in addition to all the other potential problems you'd have there, because law enforcement's obviously not going to believe that you're really truly sharing it for free, and they're going to send it undercover to contact you and try to get you to say that you want a donation. But it's a $20,000 fine for each violation. $20,000 in addition. So it's a new penalty under Smart and Safe, $20,000 fine if you actually advertise your willingness to share marijuana. So that's a really important thing. And that's obviously was put in there by the industry. Look, the industry wrote this thing. This wasn't, unfortunately, a cannabis consumer initiative. I know Dave and I, Safer Arizona, had an initiative that we were collecting signatures on that we tried to get on the ballot in 2018, but we didn't have any funding. And we still collected about almost half the number of signatures required, which is pretty good, especially in the middle of the summer, volunteers standing around collecting signatures in 115-degree temperature. But the industry funded this initiative. They controlled it, and they don't like delivery businesses and stuff like that because that's their bottom line, right? They don't want people to even be able to advertise that they'll share marijuana. And so they imposed this additional $20,000 fine. So again, you cannot sell the marijuana you grow. No form of compensation or what is referred to in the Smart and Safe as remuneration, something of value, anything of value, even a trade. Like, I'll give you marijuana if you work on my car. That's going to be considered a sale. That's something of value. So you can't barter either. If you get caught, then you'll be charged with sales. So compassion, and I'm emphasizing this because I'm seeing a lot of things on social media. People are calling me, emailing me, and it feels like it's deja vu all over again. And we're back in like 2011, 2012, when all of these compassion clubs and farmers markets, which I thought were great, and delivery businesses were all operating. And I was doing my best to defend them when they were getting busted. But again, as I mentioned in 2015, in that case, State v. Matlock, that's why after 2015, you didn't see any of them. Shut them all down. No matter what their business model was, after Matlock, all of the compassion clubs and farmers markets were shut down because even though most of them were saying the marijuana is for free and you're just paying a consultation fee or a delivery fee, or you're paying for a pencil or a t-shirt, not for marijuana, all of that got shut down. And the only thing we still see today are delivery businesses, which get busted on a regular basis all the time. It's just a matter of time because most of these delivery businesses advertise. And like I said, they got rookie duty. These cops are every day looking for people, delivery services to investigate and bust. A lot of times they let them operate for a few months. They'll do a handful, 3-4 controlled buys. They'll follow them around, throw a GPS tracker on their car, do surveillance, pull over people that they think just got the delivery, and build a case, not just against that particular delivery guy, but to try to find out who his supply chains are, who else he's dealing with. And they get this whole network, and then they like to take it down all at once. Some of you might remember last year, there were 16 people busted on the same day for doing deliveries. But I think you still see it because it's a moving target, kind of, it's obviously a compassion club, brick and mortar. Farmers market, there's a venue. It's pretty obvious. But a delivery business, it's a moving target. And so I think people still are willing to take the risk, but really it's only a matter of time. They'll always end up eventually busting the person. So I just want to be really clear about that because I know I hear a lot of people talking about it. And same thing, it doesn't matter if they're seeds or flower or what, or clones or plants. any part of the plant. That definition is very comprehensive. All parts of the plant, all parts are considered marijuana. And so receiving any form, anything of value in exchange for transferring any part of the plant, the only exception would be the sterilized seeds, and for to do that, you'd have to have a seed handler's license from the Department of Agriculture. But anything other than that, that's a marijuana sale. So, and they will catch up to you, believe me, because these cops are looking, they're all strategizing right now. I mean, we have COVID, so you're not seeing a lot of busts, you know, you're not seeing a lot of headlines because they're not filing new cases right now. They're still doing the investigations, and there's a lot of referrals, criminal referrals sitting on the county attorney's desks, the attorney general's office desk, but they'll get to it, believe me. And they're looking for ways on how to, because there's a lot of people that make a living off of busting people for marijuana crimes, detectives and cops. I mean, it's a big stream of income for the courts, for prosecutors, probation officers, treatment facilities, corrections officers, jail people, a lot of industry, a lot of people depend on marijuana prohibition to pay their mortgage, put their kids through college and all that kind of thing. I mean, so they are definitely not just intending on going quietly into that last good night. They're not thinking, oh, they legalized marijuana, I guess we'll have to find something else to do. No, they're studying these laws very carefully and finding out how they can still bust people. And one of the main ways is people who are running around doing delivery businesses or selling seeds online or whatever, advertising in weed maps, wherever, they're going to be targeting those people, as well as people who post on social media that they have 20 pounds of marijuana at home or whatever. They're going to be looking, you're going to have a whole new game plan. And that's right now they're developing their new policies and procedures on how they're going to go after people. DUIs, they're still going to try to do that. Taking kids away, so which is big business too, by the way, in the dependency courts. You got guardians ad litem, you got all the judges, you got all these treatment facilities that they make parents have to go to get their kids back, and the prosecutors, Attorney General's office who prosecutes these dependency cases. So that's big money over there too, the whole juvenile court system. So believe me, they're looking for ways to stay in business. So you got to be really careful. And I guess that's kind of the note that I want to end on, because I'm not trying to be, a Debbie Downer here. I don't want you to come in and see me, after the fact you getting busted. And now, you need an attorney. It's all of a sudden it's really expensive for you. And you're facing these scary potential prison time consequences. I don't want that to happen. I want to be able to be as clear as I can about the new law so that you don't get busted, so that you don't end up coming into my office and me having to figure out how to get you out of a real bind. And, I can do some pro bono cases, and I know people, I have a reputation for taking on important cases on a pro bono basis, but those are typically where the person genuinely doesn't have the ability to pay, and it's an important issue. Like, for example, having more than an ounce of marijuana at home, that kind of issue that's important to the whole community. Those are the kind of cases I do on a pro bono basis, but not obviously if it's someone who just gets busted for selling marijuana and just gets caught operating a delivery business or something. I mean, that's what the public defender's office is for. And I generally, I'm not going to do a discounted or pro bono basis for that. Okay. But I don't want you to have to be in a position where you need to deal with that and have to hire an attorney. So that's why I'm being so clear about these pain points, I guess, these areas that are unclear, because I don't want you to be the guinea pig that has to go through the system, because it ain't no fun. Okay. So with that, we'll do a last question and answer section, and then we'll wrap it up. Thanks everybody for your attention so far. This has been good.
All right, we got Justin.
Justin, go ahead, Justin, unmute.
Hey, Tom, nice talking to you again.
Yeah, man.
Last time I talked to you about the seeds or whatever,
Yeah.
last time we talked.
I remember,
With what you were talking about, with being able to consult. So would that mean that we'd be able to create like a consulting company where we'd be able to consult, help them build and determine what's wrong with their plants?
Yes, I believe, I don't see any, I mean, as long as it's, this is a legal activity, it's lawful. And unless I guess the only caveat is if you have reason to believe that they're cultivating more than they're allowed to, or that they intend to sell the marijuana they cultivate, you can't then give them advice because now you're an accomplice. You're aiding and abetting that. So, but as long as, you're, confident that they understand the limitations and that they intend to, act in compliance with the smart and safe law, then there's no reason why you can't get paid giving them advice how to do it.
Yeah. So if we made a company and then we put the we're only doing it if they're staying within like the law,
Mm-hmm.
and if we know that they're not being compliant within the law, we leave. Or like we're not
right
consulting or anything, then we'll be 100% fine.
And that would go into your agreement with them.
All right, cool.
Right. So you have a company, you would have them sign an agreement, and that just like you would in any other consulting business. And part of the agreement they would promise that they will remain in compliance with all laws and regulations pertaining to the cultivation of marijuana under the Smart and Safe Arizona Act. That would be one of the things that they agree to, so that if later they got busted doing something wrong and the cops were seeing you going in and out of their house thinking you're involved, you can say, no, I'm just providing consultation. I didn't know anything about they were selling the marijuana. In fact, here's my agreement. They promised me that they would be compliant. So if they weren't, thank you for bringing that to my attention. I'll no longer be working with them, but I didn't have anything to do with any of the illegal activity.
All right. So would the best way to be going about that business be like an LLC probably, huh?
Yeah, an LLC. And yep, I would recommend an LLC. And, it's like a lease. If you're a landlord and you want to let someone grow marijuana there, part of the lease is them promising that they will remain compliant. And either if it's a home lease, because you can still be evicted for all this. Okay. There's nothing you can do to stop a landlord from throwing you out. So, preferably, if you are renting, you're going to get your landlord's permission in the lease, and they're going to require that you promise to remain compliant, so that if a person gets busted and they go to the landlord and they say, oh, there's an illegal grow here, we're going to forfeit your house. The landlord says, what are you talking about? I didn't go in there. I didn't know what he was doing. Growing marijuana is legal. I told him, sure, go ahead. But he promised me to do it legally. So that means the landlord's what we call an innocent owner and is not subject to forfeiture. It's the same kind of thing with the consulting. When they come back to you, you're just an innocent consultant. You didn't have any knowledge of any illegal activity, but you want to make sure that that's in writing, among other things, in the agreement that you sign with the person for the consultation business.
And our consulting would be able to be for both recreational and medical, correct?
Yes. Yep. Now, just real quick, though, if it's medical, in order to go into their grow, you also have to be a registered patient. You can't go into, you have to be a card holder to go into a patient or caregiver grow. Okay. So don't go, you can't just go in there.
All right, sounds good. I'm
yeah. Okay. All right, Justin. Thanks.
Yeah, I'm a patient. So, thanks,
okay,
man.
Cool. Yeah, cool. I thought you were, so no problem there. Anyone else have a question? Okay, we got a few. That's cool. Oh, Galaxy, is that my man, Big John? We can't hear you.
Yeah.
Oh no, it's not. Sorry, I thought you were someone else.
Sorry.
Go ahead.
Yeah, no, Big John.
All right, go ahead.
Yeah, so I was thinking, when somebody, okay, so let's say our dispensary is the only places to sell, like, marijuana wise. So let's say somebody wanted to start a business like, selling edibles or such, we would have to go through, like, what is it? Like, would we have to get a food handler's card and something else behind that to do
You would
that?
either, yeah, and actually I do a whole seminar on this one so you'd either have to have a license yourself or be operating under somebody else's license as like what we call a management contract. So a cultivation management contract or a concentrates management contract, and that kitchen management contract, that sort of thing. And I do a whole seminar. It's a paid one because basically my policy is that if I'm teaching people how to make money, then I charge money to teach them how to do that correctly. Like whether it's trying to apply for a license or getting a contract with a dispensary or marijuana establishment to make money there. So I do have a paid seminar though that goes into great depth on management contracts. So you want to be a cultivation company or an extraction company or an infusion company or all of the above. Then there's a very, you can do that. Yes. To answer your question. Yes, you can do that under contract with a license holder.
Okay. All right.
And if you're interested in getting into a 2-hour in depth on that, then we'll probably have a seminar. I think you'll probably, if you got the email about this seminar, you'll get the email about that seminar. I think when is it, Kim? It's on the next one on that topic. The management contracts is on the 20th of this month. So if you're interested, you can sign up for that one. But yeah, you can't do it yourself, but you can do it under someone else's license.
Okay, and so for wanting to, like, let's say, yeah, growing your own supply and stuff, not like selling it, but giving it away is basically legal. It's just that you can't advertise it at all. Like you just have to like, oh, here's that,
Yeah, you can't advertise it at all. And that's because the industry thought, okay, wait a second. People if they know that they can't sell it legally, they'll just put advertisements up there and say, hey, I got marijuana to share if anyone's interested. And then you'll call them and they'll be like, yeah, but it's by donation. And so they're saying, well, we'll even make that, because that's not illegal. It's not illegal to share marijuana. It's not illegal to advertise that you're willing to share. But they're so paranoid about, being threatened by delivery companies that they made it a fine. It's a civil fine. It's not a crime. It's a civil fine of $20,000 just to even advertise sharing for free, because they think that anybody that did that really is probably going to be, when you call them, is going to tell you it's by donation or a delivery fee or something like, or consultation fee or something. So that's why they put it in there. It's really disappointing that they did, because that makes the industry, or at least the part of the industry that was responsible for that provision, that makes them, part of the war on drugs now. They've actually, it made it worse for people, but yeah.
Okay, and then back to your one on hemp. So hemp grow. So there's no like limit to growing hemp.
Yeah, there's no limit. You have to have a grower's license. There's grower's license, harvester's license, processor license, transporter license, all of those things, depending on seed handler's license, depending on what you want to do in the hemp industry, you have to get a license. The only thing that doesn't require a license is retail of hemp products. So like, you can buy a hemp product or CBD product at Target. They don't have a license to do that, but everything before it got to them to sell retail, all of that did require a license.
Okay. All right. Yeah. All right. Thank you.
You bet.
All right. Dave?
Okay, Dave, go for it.
Not to give away too much on your paid thing, but you said you can sell it to a dispensary under their license? Can you still
No.
do that as a home grower?
No, first of all, you can't sell marijuana to a dispensary. So first of all, you absolutely cannot sell marijuana to anybody, including a marijuana establishment from a home grow. Secondly, when you're under contract with a dispensary, you're not selling the marijuana to them. In fact, they own all the marijuana that you're producing because it's their license and they're the only ones who are allowed to own it. So it's technically already belongs to them. But what the management contract will say is that you'll pay them $50,000 a month, the license holder, and then as a compliance fee, what's usually called a compliance fee, and then you keep the revenue after that $50,000 a month from the wholesale of what you produce. That's in a nutshell how that's structured.
Do you have to have a cultivator's license to do that?
There's no such thing. There's only a marijuana establishment license and a medical marijuana dispensary license. They're vertically integrated. So cultivation, processing, manufacture, packaging, transportation, wholesale, retail, all of those activities are under the one license. It's not like Colorado, or California where they have the different licenses for those different things. It's all just the one license. You then become what's called a facility agent of the marijuana establishment, and you have a contract with the marijuana establishment to engage in certain activities under their license. So it's very commonplace, very prevalent, and it has been in medical for 10 years, and it will be under the Smart and Safe Act as well. So, but you got to do it right, and it's a misnomer to say that you're selling marijuana because everything's going through their license. So the whole sales go through their license to the other marijuana establishment, or if they may be retailing your product as well. But then all of the revenue then comes back from that wholesale through their license, minus the $50,000 a month compliance fee. And I'm just saying 50,000, for example. It might be 20,000, it might be 70,000. It's whatever you negotiate. And if it's processing, it's less. I mean, it's everything. We're just talking about cultivation right now. Comes back through that license to the license holder, who then dispenses that to the cultivator as payment for the cost of production. Okay, that's basically the model.
So do you see the other stages like they have in Colorado or California coming here anytime soon?
Maybe, possibly in 2024. There's a couple proposals that might make that happen. If it gets on the ballot, I think it would have a good chance. So maybe, but it would have to be in the form of a new initiative because the legislature cannot modify this initiative because it would violate the Voter Protection Act, which is part of our Constitution, which was enacted in 1998 in response to the government's refusal to implement our first Medical Marijuana Act back in 1996. So it's a good thing. It restricts the legislature from, undoing the will of the voters, but it ties the legislature's hands. So they can't do anything to change it, to that license structure. It has to be done by a new voter ballot initiative. Okay. All
okay.
Right.
What does it take to prove you grew it?
Say what now?
What does it take to prove that I grew the however much weed I have?
I don't think I understand the question.
How do you prove it?
Okay, say a cop comes to your house.
Yeah.
You got to prove that you grew X amount of weed. How do you prove that?
I guess it's just, first of all, through electric bills. So if you got 50 plants, you better have been growing your 6 plants for a while, right? Because they're going to take you some time. Let's say if you're really good, maybe you get 5 pounds off of each harvest. So to get to 50 pounds, that's 10 harvests. So you better be able to show accelerated electricity bills, for the period of time it would have taken to produce that marijuana. You know what I'm saying?
Yeah.
That's the only real way, other than, witnesses, testimony, your roommates or family or whatever, who can say, yeah, he's been growing the marijuana there for this long, and, he harvests it and he puts it in this vacuum sealed bags or whatever. But you also better be able to show utility bills, because they'll definitely go and get them. The prosecution the law enforcement will get those utility bills. So you better not, have no increase in electrical use at all. And then all of a sudden got 50 pounds of or 20 pounds or 10 pounds or 5 pounds or whatever you were talking about. Yeah, if it's outdoor, I guess that's different. Probably your neighbors would be able to say, yeah, I've been seeing those damn marijuana plants for 6 months now. Right? Okay, cool. All right. Thanks. Thanks for questioning. We got one more. Good. Omar.
All right. Going back to the whole consultations thing, I'm sure it wouldn't be a problem to advertise specifically pertaining to cannabis. What do you think?
To advertise for what?
Consultations, specifically for cannabis.
Yeah, that's fine. As long as you don't say anywhere that you're going to be providing marijuana, then that's fine. You can advertise consultation.
Sounds good. Thank you so much.
You bet. Okay. Is anyone else? We got everybody? We got everybody. All right. Awesome. Hey, thank you so much, everybody, for tuning in here this evening. I hope that I was able to provide you with some useful information, and that we got all your questions answered. Keep an eye out for future seminars on topics that you might find interesting. Good luck. Try to do things right. Avoid getting busted. If you do, I'm here to help. But hopefully I don't have you coming in to see me about anything illegal that we talked about here today, or even in those gray areas. So stay safe, stay compliant, have fun.